All right, welcome back. I've hopefully got a good one today. I haven't watched this yet, so it's a complete reaction. I realize I forgot to do this my last couple videos, so for those of you who are new here, hi, I'm Joe. I'm an attorney licensed to practice in Utah. So yeah, do all the YouTubey things like share, subscribe. I usually forget to do that until the end of the video, but remembered since I introduced myself. So for this one, we are headed to St. Joe County again, visiting our good friend Judge Middleton. And this video is provided by the channel Lone Wolf, Lone Wolf USUL. He provides lots of court videos, does a good job finding them. Go give him a subscribe. And so, yeah, this video is Judge Middleton deals with a walking contradiction. So let's jump into it.
Good morning, sir. This is Judge Middleton. Are you Chase Randall Jones?
Yes, Your Honor.
Mr. Jones, we've met, but I want to identify you for the record. I'm here at the courthouse with your lawyer, Mr. Ross Truckee, and Chief Assistant Prosecutor Joshua Robert. You got charged on September 15th with possession of methamphetamine and possession of a dangerous weapon. Your lawyer, Mr.
Yeah, drugs and weapons are generally not a good mix. I mean, you know, I don't want to get political here, but ask Hunter Biden. You know, if you have drugs on you and a firearm, you could be looking at serious time because it makes what could be a misdemeanor into a felony. It's bad news.
Truckee is here with me today, and so is Mr. Robert. The matter is set for a pre-exam conference. We're struggling with the fact that your attorney in your circuit court case, Mr. Sopanos, has filed a petition to argue that you're not competent to proceed in that felony case.
December 18th.
So, little background, just like I said, I haven't watched this at all. So, I'm assuming he has multiple charges because he's got a circuit court case, which is a felony, which, like I said, if you have a weapon and drugs, it can be a felony. So Michigan courts are a little bit different than what we have here in Utah. So, you know, here in Utah, we have basically the municipal courts or justice courts, which are kind of like the district court that Judge Middleton sits in. But then we have the district court, which is the main trial of general jurisdiction, just like in the federal courts. And then we have Court of Appeals and Supreme Court. In Michigan, where St. Joe County is, so you have district courts, which hear misdemeanors all the way through. And I could be getting this a little wrong. Like I said, I'm in Utah, not in Michigan. But then they also have circuit courts, which are the trial of general jurisdiction, which to me is weird because to me, I think the federal system, that circuit court should be the first level of court of appeals. But they do this weird hybrid system in Michigan where even circuit court cases, the initial appearance and the arraignments seem to mostly, I'm not going to say all, but mostly happen in district court, and then they're bound over and sent to circuit court. We don't do that here. It's if a court's in justice court, it stays in justice court. unless the defendant loses, then they have they can appeal de novo to the district court, meaning they can have a whole new trial from scratch. And so my old boss used to tell me, because you don't get preliminary hearings in justice court, he said, yeah, just take it to trial and treat it as if that's the preliminary hearing. And if you win, great, it's dismissed. If you don't win, hey, it was a preliminary hearing, just appeal it to district court. So my long-winded aside, you know, basically, I I don't know if this guy, if it's separate charges he's talking about for the circuit court, or if the circuit court sent it back to Judge Middleton to conduct the forensic examination to determine if he's competent, or if the circuit court is going to do that, but since they're doing it, if he's incompetent in one, he's probably incompetent in the other. And so it might be Judge Middleton saying, well, if the circuit court's doing it, I want to push the brakes and either conduct my own or wait for them to do it. So, like I said, haven't seen it yet. This is just me working it out.
Hey, Your Honor,
Yes.
I thought the charges were aggravated assault and possession of meth.
Well, this shows assault with a dangerous weapon, which is different.
So that can be different. Aggravated assault is basically, assault. So the unlawful touching of another, or unlawful, causing the unlawful apprehension of unwanted touching. It's here in Utah, we don't have criminal battery. We just have assault, which kind of covers both battery and assault, even though they teach you the common law assault in law school. But aggravated assault, there's going to be, as the name implies, some aggravating factor. And a dangerous weapon could be such an aggravating factor. But then, like I said, because at least here in Utah, battery is encompassed in the assault charge. Strangulation, that would be common law battery, but here it's assault. That's the unwanted touching, but strangulation, that's causing the disruption of airflow, disruption of bodily function. That's an aggravating factor. So that's aggravated assault. And that's the main one I can think of off the top of my head. There's a list, as I'm sure you would imagine. But he was charged with the dangerous weapon, unlawful possession of a dangerous weapon, whatever Judge Middleton said. In theory, he could have been charged with both. I don't know if one's like a lesser included crime, or either way.
It might have started as aggravated. So the problem is, we're stuck with the fact that there is a petition in circuit court for your competency. So if you're challenging your competency in your robbery case, but acknowledging that you are competent for this case, we can't do both. Have you?
So yeah, it sounds like this is a separate case, but like you said, and I'm not going to rewind. I think it sounds like he's got the same attorney in both, but I can't remember. But if this is kind of a conundrum, though, because like Judge Middleton said, you can't assert you're competent in one case, but incompetent in the other. But let's say he has two different attorneys, one in circuit court and one in district court in 3B, and the defendant is not asserting anything. The circuit court lawyer says, I have concerns about his competence. I'd like a examination. Whereas the district court defense attorney says, yeah, he's good, let's go. That's not the defendant asserting anything. So, you know, I could see an argument against what Judge Middleton said, but I also think even if that were the case, my hypothetical, Judge Middleton is still playing it safe by doing it this way, saying, yeah, if there's a question in one, there's a question in all.
You got an appointment with the censor for the forensic center yet?
No, Your Honor. That wasn't even my choice, Your Honor.
Yes.
Like I said, the attorney, because the attorney gets to decide strategy, and so, you know, especially if the attorney thinks you're not competent, he's gonna say, hey, look, we need this. The defendant, of course, gets to decide whether or not to plead. You know, he gets the final say, guilty, not guilty, nolo, you know, whatever. And so he gets to determine the outcome, at least up to trial, but the attorney gets to decide the roadmap. If you don't like the attorney's roadmap, you can get a different attorney. Unless, of course, you have the public defender, which he does, in which case, hey, make better choices so that you're not in this case, or you can hire your own attorney.
But yeah, that wasn't even my choice to decide whether I'm competent, Your Honor.
Well, I didn't have any part in that proceeding. Judge Stutzman signed the order, but arguably the person who may or may not be competent isn't the best person to decide whether they are competent.
Yeah, if you're not competent to stand trial, you're probably not competent to declare yourself competent.
Understood.
So they're asking for some experts. I've met you before, and
Yes,
we've
Your
been
Honor.
in court together, and I never had any concerns about your competency. You were always polite, respectful. You seemed to understand what was going on. There were some very serious charges, but that was several years ago. So I don't know what's happened since or what's going on with you. But I think the safest thing to do, your bond has been canceled in the circuit court. So even if I gave you a PR bond, you can't get out. I'm going to continue this to.
So my understanding with Michigan, I don't actually know this distinction because, like I said, I'm not a Michigan attorney. I'm a Utah attorney. But my understanding in Michigan, in order to get credit for time served, if you are eventually found guilty, is you have to be sitting in jail with a bond. If you're held no bond, you don't get credit or something like that. So I don't know if a PR bond functions the same way, because in theory, a PR bond, he walks, but he's being held under the circuit court no bond or high bond, whatever. So he's not getting out anyway. So Judge Middleton putting a bond, frankly, is doing him a favor because he's sitting there anyway. So he may as well get time served for the time he's serving pre-trial.
Mr. Truckey's next.
Your Honor, can I say something for the record?
Yes, sir.
Don't.
I'm stating for the record, in case this goes to appeal, or whatever
Yes.
has to be done, in case this case goes further, then my
Okay.
due process is being violated
All right.
for the preliminary.
Whoa. I'm stating this for the record that my due process is being violated. Wow. I love those conclusions of law from the defendant telling the judge what due process is and that it's being violated. That's a galaxy brain move. Well, just, I mean, yeah, it sucks that you're sitting there in jail. Judge Middleton could dismiss the case right now. Just say, you know what? I think you're competent, and I think this charge is a load of nonsense. Dismissed. See you later. He's still going to be sitting in jail waiting for the forensic exam from circuit court. So Judge Middleton isn't doing anything violating his due process rights.
Exam. I've been here over 30 days, and my rights are being violated by holding a preliminary exam at this point.
Wait. My rights are being violated by holding a preliminary exam at this point. They're not holding a preliminary exam. They're doing a forensic exam. Those are very different things. One is to find if there is probable cause. The other is to find out if you're doolally.
All right. Well, we aren't going to hold a preliminary exam. We're going to continue it to December 19th.
Oof. That's a month and a half.
But your concern is on the record, and we'll set a prelim if.
So my
Yes.
charges aren't being, I'm confused, Your Honor.
Well, this is a pre-exam conference in advance of your preliminary examination. Your prelim was set for next Tuesday at 1 o'clock. The prosecutor.
So basically, Judge Middleton could tell him, Judge Stutzman is keeping me from seeing you next Tuesday.
And your lawyer are both reluctant to do the prelim, and frankly, me too, while this competency petition is pending. So I've noted your objection for the record. The prelim is December 9th. The prelim will be December 27th.
Oof.
I believe the 26th is a holiday.
It's a long way.
Your Honor, I may have
Yes.
worded it wrong. That's
All right,
past-
what you meant to say is your rights are being violated because you don't get your preliminary examination. Is that what you meant to say?
Absolutely, it's past 21 days.
All right, I got it. So your objection is preserved on the record. Your lawyer will be out to see you. And if the competency order comes back sooner than that, that's got to be dealt with within 5 days of the receipt of the order. We can move this date up. My concern is this may not even be enough time, but I'm going to continue it to December 19th at 8:30 with a prelim, if needed, December 27th. Your objection is noted on the record. Good luck, Mr. Jones.
Your Honor, in this file, should there be some resolution in the other case, it's dismissed or something, and what is the bond situation?
Bond here is $50,000 cash or surety.
Yeah, that's That's a mighty big bond. I mean, he yeah, just even for felonies, like here in Utah, 50,000, unless it's a very violent class 3 felony, I wouldn't expect nearly that much for a class 3. Uh, uh, Class 2 felony, maybe, and I say class 2 and class 3, that's first degree and third degree. It's class A, class B, and class C misdemeanor. Uh, Misdemeanors are classes, felonies are degrees. But first degree, you can be looking hundreds of thousands, millions, just depending on all the factors that go into it. Or, I'm going to get back to it hopefully soon, but Ruby Frankie sitting with no bond because, she's evil and she has the resources to flee. So
I don't see what this
All
case
right.
has to do with the case, but
Yes. All right. Good luck, sir. All right, that room worked well enough. All right, he's got a concern, which is, he sounds pretty competent to me, frankly, so his concern is appropriate. His demeanor was appropriate, but
and Judge Middleton has a point. The competence is, frankly, it's a fluid thing. And there's the question, at the time of the crime, were you sane? Did you know right from wrong? But at trial, or at least in the court process, the question is, are you able to understand the charges against you? And do you have the ability to assist your attorney in your own defense? Now, that doesn't mean go out and collect evidence and, examine the witnesses on the stand, do the cross-examination. No, it means you're able to coherently understand questions from your attorney and answer them and, give them the responses they need in order to defend you. Well, this guy, he knows, hey, I'm getting railroaded sitting in jail for 2 more months because some yahoo up in circuit court doesn't think I'm competent. That sounds competent to me. So, of course, I don't know what their concerns are up in circuit court. So, either way. But, so yeah, it could be that he is competent. From what we've seen, he probably is. I'm not a psychologist. I can't, if I were his attorney, at least based on this, I wouldn't have the concerns. I wouldn't be referring him for a competency evaluation. But I'm not his attorney, so I don't know what they've observed. But Judge Lone Wolf's title certainly is valid. Judge Middleton deals with a walking contradiction. He doesn't think there's a problem, but since circuit court's doing it, it's better for Judge Middleton to do it too, just to, if he's not competent up there, he's probably not competent here, even though the observations are he is competent. So that is quite the catch-22. But what isn't a catch-22 is you should go and subscribe to Lone Wolf, USUL. Thank you to him. I assume it's a him. It's AI voice. So, but either way, subscribe to him, subscribe to me, like, share, do all that stuff. And I will see you real soon for the next one. Bye-bye.